All right, wonderful. Thank you. Yeah, just a reminder, I sent the first of two forms in the chat. So if you don't mind filling that out, and then the second one will be sent at the end of the presentation. And so those two are required for the continued education certification. And without further ado, I think we can get started.
Shall I proceed by introducing myself, or is somebody going to do that?
You can do so with the next slide. That would be great.
Okay. Good afternoon. My name is Robert Kinscherf. I'm the Executive Director at the Center for Law, Brain, and Behavior at Massachusetts General Hospital. And today we're going to be talking about the law, what clinicians should know. And the goal here in the next 90 minutes or so is not to turn you into lawyers, nor is it to inflict a disabling degree of anxiety upon you. I've certainly seen some people give law and risk management talks where at the end of the talk, the only reasonable question is, where can I get some cheap scotch and surrender my license? But I think the real important part is that the framework of law is really an effort to balance interests and rights and powers, and to distribute risks across vulnerabilities. And they all come together to reflect sort of a social consensus about what it is and what it is we want to be doing when we're behaving as clinical behavioral health professionals. Feel free to send questions into the chat. If it's something right on point and immediate, Jack may choose to go ahead and read it into the conversation. I'd like this to be as conversational as webinars can permit, but I will also leave time at the end to go through questions that you may have had along the way. And if I haven't answered them, then that'll be an opportunity to address them together. I have no relevant financial interests to disclose in doing this, and I will not be hawking either on-label or off-label any commercial products. So what I'd like to do is provide you today with a framework about thinking about the work that you do every day as behavioral health clinicians. And to do that, I'd like to offer you a model of thinking about how to address situations that may be challenging or unfamiliar, or where reasonable people might reasonably disagree about what the most prudent course is to take. The good news for us is that the world does not expect us to get it right 100% of the time. They understand that there are bad outcomes in any kind of clinical endeavor, especially in cases where the stakes are high for people. But they do ask us to be thoughtful and prudent when we do make the decisions that we make, and that we sit somewhere in a consensus of professional judgment and decision making. So we'll think about how to do that by looking at the 4 buckets of decision making to make sure that when we ask and answer questions, we know which bucket we're in. Along the way, we'll talk about places, certainly more than 2, where law balances competing rights or interests and allows us, in most cases, considerable discretion in trying to figure out what the most prudent and fair balance would be. Other times, it will require behavior from us, as in the mandated reporting context, for example. We'll have a conversation about why informed consent or assent is at the heart of a therapeutic relationship. I think it's critical to understand that it's the process of informed consent is really not the process of getting somebody to sign a piece of paper at the beginning of your professional encounter with them. It's an ongoing process in which you figure out what your joint goals are, the methods that you're going to use to achieve those goals, and the risks, benefits, and alternatives to the methods that you may propose that that you work with together. We'll talk about that more. We'll distinguish the broad bucket of privacy, which as a profession we've tended to encourage as a way of getting people to be vulnerable to us, to share with us to allow them to hear from us about things that may be very sensitive or painful for them. But privacy is not unlimited, and it's, as we'll see, one of those things where there are other balances that sometimes have to be struck. And the difference between confidentiality and testimonial privilege, which are important but very different aspects of privacy. And finally, we'll talk together about what constitutes a standard of care and its importance for legal and ethical decision making. And I put the two words together, legal/ethical, because there's considerable overlap between law and ethical practice, or the ethical standards of our individual professions, as we'll see along the way. The grand mantra here is that good clinical care is good legal, ethical, and risk management strategies and approaches. And good legal, ethical, and risk management approaches do constitute the components of what is good clinical care. It's hard to imagine how you could provide good clinical care while operating illegally or recklessly or unethically. And so sometimes people think as though these kinds of boxes, legal, ethical, and risk management, are somehow in opposition to the box or the bucket of clinical care. But in fact, they're often quite complementary, and we ignore them to our peril, not just legal or ethical peril, but also our clinical peril. So I want to set the frame a little bit. It wasn't always the case that we had regulated professions. For the most part, the regulated professions emerged slowly out of the 19th century. At the end of the 19th century and the beginning of the 20th century, you knew you were a lawyer when enough people read the sign on the side of your house or where you worked that said attorney at law, and they took their business to you. That's roughly the same way that people knew that you were a physician. Most attorneys, physicians, and other professionals were trained not in the law schools or the medical schools that we think of today. They were largely taught by apprenticeship, and there was considerable disparity amongst people as to what would be an adequate apprenticeship to do what sort of work. And in fact, some of the key caregiving professions, physicians, for example, overlapped in some of their skill sets. So those of you who would recognize a barber's pole with the blue stripe, the white stripe, and the red stripe may remember that the red stripe was not on all barbers' poles originally. The red stripe was only on barbers' poles where the barber also did surgery or dental surgery. And so they were not even really considered to be in the physician box at the time. In the early 20th century, the vast majority of people who practiced as physicians or attorneys had never gone to a law school or gone to a medical school. They had apprenticed. And those that did something more than apprentice typically took correspondence classes. You could be a physician, for example, without ever having done a physical examination. You could be a lawyer without ever having tried to write for a law professor an affidavit or a case squib. So the origins of the regulated professions emerged out of this effort to really create a core consensus about what was good practice in a variety of different professions, including at the time, fairly arcane part of the medical profession, which originally had morphed out of neurology in the 19th century. The people who would be known in their era as the alienists, we call them now psychiatrists. And it's worth remembering that the emergence of the regulated professions was really a post-World War II endeavor. And they arose out of very complicated and often terrible circumstances that that occurred during the Second World War. So the very first international principle of fundamental human rights and dignity emerged after the Nuremberg trials in the late 1940s, right after the Second World War. involving the trials of physicians who had done medical experimentations on persons in occupied countries or persons in camps that they ran, most notoriously the concentration camps. But even prior to the Second World War, had done medical and other experimentation on people that the National Socialist ideology regarded as largely subhuman, including any person with a serious physical or mental disability. And the prosecutors at the time in Nuremberg, right after the Second World War, they were a little bit challenged as to what was going to be the legal theory of the prosecution. Prosecution which, if convicted, could have led to the doctors being executed for their crimes. And they had two problems. One was, ordinarily, people can only be held to account for crimes that they commit if they are in a time and place in which those crimes are already defined as crimes. They're already illegal. In our legal tradition, we don't like people looking in the rearview mirror and saying, well, it may have been legal when you did it, but it's not now, so we're going to prosecute you for what you did 5 years ago, 10 years ago, 20 years ago. So that was one problem, sort of the ex post facto. We don't like to look in the rearview mirror and later prosecute people for things that were not illegal. Remembering that what the German doctors did, the Nazi doctors did, was absolutely legal in the jurisdiction in which they did them at the time that they did them. It was not a crime to do medical experiments on unwilling prisoners or persons kept in captivity in concentration camps. So there was a jurisdictional problem. There was also the problem of where you would actually look to law. People often say, well, that doing what they did in the concentration camps with medical research must have been against the Geneva Conventions. It was not against the Geneva Conventions as they existed at the time. The Geneva Conventions that we arrived to with World War II largely protected combatants against combatants. It wasn't until subsequent legal conventions, Geneva Conventions, that rules were made about the behavior of people who occupied lands. And so the theory of the prosecution was actually really quite novel. And it was, there are some things that are so fundamentally a part of basic human dignity that you cannot violate those dignities, those rights, those fundamental rights, and still remain a sovereign state whose rule of law is to be respected. And essentially, the doctrine of informed consent for medical research became the first recognized international fundamental human right, the violation of which could strip a government of its legitimacy, including the legitimacy of its own laws. And we like to think that maybe this all arose because of terrible Nazi doctors during the Third Reich. But the reality is that American examples of, and other countries, other of our peer countries, American examples are rife with examples of medical experimentation with either unknowing or unwilling participants. Notoriously, things like the Tuskegee experiments or the experiments on early cancer research on developmentally delayed children in institutional care in New York without their parents' or guardians' knowledge or consent. With this doctrine of informed consent, which, by the way, organized medicine and then organized psychology and the other professions resisted strongly, which is why they never imposed it upon themselves until after the legislatures had already imposed it upon them through the form of licensure and regulation. This drive and the recognition that it needs to be taken seriously helped push the rise of licensure, first of physicians and other attorneys, other major professions. And then as these professions emerged in clinical care, psychiatrists joining the other physicians, psychologists, social workers, licensed mental health counselors, and a variety of other folks that would come on board as what we now think of as behavioral health clinicians. And with the rise of licensure, which was imposed upon the professions by legislatures, came what the lawyers would call enabling legislation, basically saying the legislature will authorize the creation of a profession of psychology, for example, or social work. But the enabling regulations or statutes is what allows people to then write the actual regulations to govern them. And in many cases, the regulations themselves create legal meaning for the ethics code by incorporating them by reference into their own regulations. So if you're a psychologist, the Ethics Code of the American Psychological Association governs the conduct of members of the association. And the worst thing that the APA can do with you if you violate in any serious way their ethics code is to throw you out of the association and refuse to cash your membership check ever again. However, most states, for purposes of psychology, have incorporated by reference the ethics code of the American Psychological Association. And if you violate the code in the view of a state licensing board, then the worst thing that can happen to you is that your license can be permanently revoked. And for some behavior, you might even be criminally referred. But we did see after, especially about 1950, the rise of the professional associations and the ethics code, the incorporation by reference of these codes into regulations so that they have legal as well as ethical valence for us now, and the overlaps of conversations in legal and ethical constructs like the scope of practice and licensure. What does a license allow you to do in any particular jurisdiction? Because they will all vary by a state and sometimes by sub-profession inside of the profession itself. What do we mean by a standard of care, or that a practitioner made a reasonable or prudent decision within that standard of care? And beginning to think and distinguish, recognize and distinguish amongst preferences. We all have preferences. Interests, which are things in which we have a material interest or significant interest at stake, and rights. Rights are absolute. If you have a right to something, then it becomes very, very hard to even think about negotiating away a right or compromising on a right, because rights are typically thought of as absolute, and they're very difficult to reconcile for just that reason. So I'd like just to briefly put this into the context of how our peer countries come to think of it. And in the United States, we have a very strong cultural value on autonomy and on independence, including the autonomy of the professions and independent judgment of autonomous professionals within a profession. But even in our system, we recognize that professions are allowed to exist by legislatures as regulated professions as part of a social contract. Now, we don't get as explicit as the Canadians do, but they, in their own ethics code, point out that we are allowed the discretion, the freedom to act as autonomous, decision-making, responsible professionals only within the contract with the society in which we function. And in a way, when the legislatures creates these boards of psychology or social work or medicine, they're doing so by entrusting us to make the best decisions, not only for what's in our interests, but what would be in the interests of our patients or clients or the greater society around us, which is a really grand bargain, has served us well in many, many different ways. So the heart of this is what in law they would call a fiduciary duty, which is the duty to have a higher duty of care to those that we serve than the general duty of care that all members of society have to each other. That is to say, once we are in our professional role, we actually have higher duties of care for those to whom we are providing our professional services than to others with whom we may have more ordinary, non-professional relationships. In the United States,
Robert,
yes.
Robert, may I ask how so, right? Why a higher duty of service as opposed to a physician, a dentist or a lawyer, attorney?
They all have the same one. This is just an example out of the Canadian Code for Psychologists. But all professions have this higher duty of care to their patients or clients than I would if I was seeing you, for example, in my non-professional capacity.
Got it. Thank you.
Yeah, this is just an example of the one profession, but you're absolutely right to make the point that all of the regulated professions have this enhanced duty of care, this fiduciary duty to put the interests of those we care for ahead of our own interests. So in the United States, we have a fairly complicated system of all of this. We have federal system, which is a central government, and we ordinarily look to them to create large systems with which the other subunits, the states, have to operate. But the federal government has considerable power, largely through its funding mechanisms, to impose expectations on healthcare systems, clinical care systems, and providers. Good examples of that would be Medicaid and Medicare, where they can expect certain kinds of behaviors or standards to be met in order to accept federal reimbursement. Another good one is HIPAA, the Health Insurance Privacy and Portability Accountability Act. Now, HIPAA sets a floor on basic confidentiality and what you can do with medical records and so forth. But states are entitled to set higher bars. You just can't go lower than the federal standard. A state can, under its own constitution or under its own legislature, set an even higher bar. The states with their own legislature all regulate, and our territories for that matter, all regulate the behavioral health professions through the various professional boards. And these boards all have some tie to appeals that may take cases into a state court system and the like. But what we're really thinking about here are the statutes that are passed by legislatures. These create agencies. They describe duties that we may have. So a mandated reporting duty or a duty to warn or protect a third party. These are all created by statute, mostly at the state level. And because they're mostly at the state level, they can vary considerably in what kind of duty it is and who it's imposed upon with what parameters. So in Massachusetts, if you read our state mandated reporting requirements for maltreatment, possible maltreatment of children up to age 18, there is a list of people who are mandated reporters. Other people are not mandated reporters unless you are on that list. In New Mexico, by contrast, their mandated reporter statute essentially applies to everybody who happens to be in the state of New Mexico, even if you're a tourist passing through. In New Mexico, everybody is a mandated reporter if they have a reasonable basis to believe that a child is abused or neglected. In Massachusetts, there's no expiration date explicitly in our statute. I mean, how long ago does something have to be before it's not a mandated event for purpose of the statute? The statute is silent on that. Contrast that with Michigan, where the statute says, and if what you've learned about is more than 7 years old, you're no longer a mandated reporter. If it's important, you have the discretion to report it if it's relevant, important to the current situation, but you're not a mandated reporter in that particular state. In Massachusetts, and I'm betting in other states that people may be practicing here, Washington, I'd be willing to bet as well. If I try to prescribe a psychiatric medication, I'm outside of the scope of my practice because there's no exception in the Massachusetts psychology licensure that allows for me to prescribe. If I have completed some additional training and work and I'm licensed in Louisiana, there are medications that I can prescribe as a psychologist, just as if I'm in the federal jurisdiction, I'm a psychologist in federal systems. If I've taken additional training and have the right kinds of supervision, I can also be a prescriber as well. So only just to say that individual results may vary, and that you really need to know the statutes that are creating important duties, like duty to warn or protect third parties, mandated reporting duties. What are the rules about the ways in which you handle records? What happens to a patient's record if they die during the course of your treatment with them? What happens to their records if you retire or become too medically compromised to continue your practice as a behavioral health professional? All of those are regulated at the state level. So statutes are these sort of big ticket items, establishing licensing board, major duties. Regulations are the ones you want to pay attention to. In your state, how often is your license renewed? How many CEUs do you have to have? What are the qualifications of somebody who is entitled to sit for licensure exams? How's the licensure exam administered? Is it all pen and paper? In Massachusetts, when I got a license, I had to take pen and paper exams. When I was in Texas, I had to do 2 days of basically live clinical interviewing in front of a panel of 3 psychologists who were, watching my work and conducting a clinical examination and offering a case formulation based on the information they gave me. Again, only to say some things are quite variable depending upon the state that you're in. Finally, there are sometimes ordinances, which are rules adopted by local or county authorities. These don't tend to have a lot of the kinds of authority that they used to be, but in some states where a lot of services, child welfare services, public health services, are still largely organized by county, there may be county provisions that you want to know about where and how you might be able to practice your profession or the services that you can offer as a professional. So basic points of, from the law's point of view, the basic goal is to provide competent, prudent practitioners who operate reasonably and responsibly in providing patient care. That's all they're asking us for, is to be competent, prudent, reasonable, and responsible. And that's actually quite liberating, because that allows us as a profession considerable freedom to choose the methods by which we provide care. The only proviso will be that if we're going to provide care, we need to go through a process of meaningful and informed consent, which I think we would want to do anyway, even if it wasn't imposed upon us. The law will tell you what specific duties you have, especially to your patients or clients or to your community, when those duties arise and what you can or must do to discharge those duties. And we'll talk about a few of those here today. You want to think of law as a roadmap with guardrails. It reflects a social consensus on balancing power, vulnerabilities, competing interests and rights, and it provides protections both for us as a profession, but also those that we serve, and to providing remedies when there are legal or ethical violations by the professional. That's part of the social contract and the deal. Here are some cases involving laws that reflect a social consensus or dispute in which there were different points of view on matters. So Elijah W. was a young man. He was about 13 years old. He was charged with a sexual offense, a juvenile sex offense, and the law required in California that if there was going to be an evaluation of a young person who had a problematic sexual behavior, the professional had to be drawn off of a court-approved list of properly trained professionals who knew how to do those kind of evaluations competently. However, this young man was also represented by counsel, and counsel said, look, there's attorney-client privilege here. Everything that I learned from my client or on behalf of my client is subject to the attorney-client privilege. If you require a court-approved evaluator who has to turn a report back to the court, including statements that my client may have made regarding his conduct, which may be relevant to whether or not he be adjudicated a delinquent, a juvenile sex offender, that's a violation of my attorney-client privilege. I should be able to choose my own evaluator who are covered under the attorney-client privilege. It was unclear in California what the balance was between a mandated report to be made by an evaluator, either appointed by the court or retained by an attorney, and the attorney-client privilege. There was a tension there. Oh, by the way, this is a completely unresolved issue in Massachusetts as to whether or not if somebody wearing their forensic psychology hat or their forensic social work or forensic psychiatry hat, whether or not they are bound by the attorney-client privilege or they are bound by a mandated reporting requirement. Completely unresolved. Reasonable people have different points of view of this, but nobody wants to be a test case. So the Patriot Act, right after 9/11, many people don't know this, but buried in the Patriot Act, which was the ramping up of a national security apparatus in the wake of 9/11, there is a provision in federal law that allows national security personnel to treatment records of persons of concern, persons who have not yet been arrested, but are of concern or of suspicion to the national security personnel at the federal level. And if they show up at your office, the Patriot Act, and they want to see the mental health records of that person of concern, the Patriot Act would mandate you to turn those records over to them, to provide them copies. And the additional provision that you can't tell your client that national security people have been to your office, talked to you, and gotten their records. Right? Tucked away there. Now, one way of looking at this is they are the Congress was trying to balance out the need to get national security relevant information on people, but they tipped the balance in favor of safety of communities and against therapist-client privilege or physician-client confidentiality and privilege. And so in New York, we've seen recently part of legislative changes in New York that reflect a national push for loosening laws about confidentiality to require the reporting of mentally ill persons in treatment who may be dangerous. Now, may be dangerous is a standard well below substantial likelihood that a failure to hospitalize would result in severe injury or death. And so people are quite concerned about how you're supposed to define potential dangerousness, how imminent, how severe does it have to be? And the Affordable Care Act, there are disputes about the status of psychology and its role in clinical care systems, behavioral and physical health, which is important as behavioral and physical health become increasingly consolidated and are no longer parallel systems as they've been for much of my career, but still parallel, but with an eye towards integrating behavioral and physical health care into overall systems. And so when I sometimes will ask my fellow psychologists, would you rather be considered a specialist or a generalist in the Affordable Care Act? And most of them will say, oh, well, it's like I want to be considered a specialist. Because I think that's because it just sounds cooler than being a generalist, right? What they don't know is if psychology is viewed as a specialty for purposes of commercial and government health insurance, then people will not be able to go to a psychologist without getting a prior referral from their PCP. How do I get to a neurologist or an oncologist or an ENT specialist? I don't walk into neurology and make an appointment directly with a neurologist and expect my insurance to cover it. It has to go through a PCP referral. And so if psychology, for example, or clinical social work are designated as specialties, then we would have to go through a gatekeeper. Nobody could just show up with their insurance card at a private practice or at a government subsidized facility, a place that takes Medicaid and Medicare, and insist on.
You muted yourself.
Mute yourself.
Wow, I didn't even touch my mouse. Okay. So I'm not sure where I quite left off, but just to say that these disputes also play out in the role of the states versus the federal government about decisions about whether or not to extend entitlement programs or Medicaid, Medicare, and other kinds of insurance schemes to people who are currently uninsured, or, as we see in the current administration, designing a system that rolls them back, although they are currently entitlements. The duty to warn or protect. Almost all of us are familiar with the Tarasoff case. It's interesting that the Tarasoff case never actually went to trial, so we don't know whether or not the mental health professionals involved in the Tarasoff case acted negligently by failing to warn the parents of Tatiana Tarasoff about Mr. Pradesh. But duty to warn or protect, highly variable across the states. This is another place where you really want to look about what the rule is in your jurisdiction. In about half the states, Massachusetts being one of them, I'm not sure about Washington, maybe the Washington folks can tell me. In about half the states, if you are in a situation that triggers the duty to warn or protect, it's mandatory. You have to take steps. In Massachusetts, there are 4 steps you can take. In Virginia, there's 12. States will vary about what you're allowed to do. In about half the states, even if the duty is triggered, it's discretionary on the part of the professional as to who, if anybody, to warn and what, if any, protective steps to be taken. And in some states, it's limited to human beings only. So in Massachusetts, we only have a duty to warn or protect human beings who may be in danger of severe injury or death. In Vermont, the duty to warn or protect also includes a significant danger or threat to property, which may make sense. The case that went before the Vermont Supreme Court was a man in mental health care treatment who threatened to burn down the barn of his neighbor, in an act of retaliation. The treating mental health professional did not think the duty to warn or protect covered things like threats to burn a barn down. It probably didn't at the time. But when it went to the Supreme Court in Vermont, they said, no, the duty to protect or warn is broader, especially when you're looking in a state that relies very heavily, for example, on farming and dairy farming. Burning down a barn and eliminating, killing the cows and livestock living in there is a pretty serious thing. So they've added it. In some places, it has to be a direct and immediate threat to a specific identified individual or individuals. So in Massachusetts, if my patient tells me, sometime pretty soon, I'm going to go to a McDonald's and kill everybody in it, that would be insufficient in Massachusetts to trigger a duty to warn or protect, because there are dozens and dozens of McDonald's. It's not sufficiently specific. In other jurisdictions, they use what's called a zone of danger analysis, which is if somebody seems to be moving into a zone of danger, even if you can't predict exactly what it would be or how dangerous it might possibly be, it may trigger your duty to take steps to protect third parties or warn third parties as they, in your judgment, move into that zone of danger. Outpatient civil commitment is another place where we balance values all of the time. The federal standard for involuntary outpatient civil commitment is clear and convincing evidence. In Massachusetts, the bar is higher. It's the same bar used for criminal conviction, beyond a reasonable doubt. And so I've certainly seen cases where judges were brought people who were at significant risk of harming themselves or others, but the judge determined that the evidence presented before the court about this person's danger did not meet the threshold for beyond a reasonable doubt. And so they were released back into the community. Gun legislation, this is another hotbed now of balancing off Second Amendment rights versus duty to warn or protect obligations versus basic public health and client health stakes. So in some states, physicians are somewhere between encouraged and required to ask about firearms maintained in the homes of pediatric patients. In other states, they are explicitly, like Florida, they're explicitly barred from asking any questions about firearms in the home, although we know that a significant number of the firearms deaths of children, especially younger children, are accidents or suicide from weapons maintained in the family's home. And testimonial privilege, which is the privacy right that is between you and a designated professional for whom the legislature has granted the special form of privacy. That varies by state as well. Who has privilege? What are the circumstances under which it can be waived, and so forth. We'll talk about that a little bit more. But in Washington and in Massachusetts, for example, both jurisdictions have recognition of doctor-patient or psychotherapist-patient clients' testimonial privilege, which is a bar permitted by the legislature to keep some kinds of especially sensitive or trusted information exchanged between a person and a designated professional with the privilege, to keep that out of court, to keep that information out of court. The trade-off for that is that if you can keep information out of court, you might also contribute to a judge or a jury not knowing something that they should know in order to achieve a just outcome. So here we're seeing again the kind of weighing back and forth of these notions. Comments or questions up to this point? Jack, do you have anything you want to toss in?
No, I think we're pretty good thus far. Oh,
okay.
Sorry, go ahead.
I had a question in regard so mandate reporting and duty to warn. Those are not new; they've existed for a while. Any changes to those, and anything that we need to pay attention in the state of Massachusetts that have come up?
I'm sorry, Natalia, I lost you there.
Sorry about that.
That's okay. Oh, any recent changes in the law in Massachusetts that I'm aware of?
Any recent changes or amendments, additions to either one, and duty to warn and mandated reporting? And is there anything unique within the mental health profession, behavioral health, when it comes to the state of Massachusetts?
Probably the most recent substantive change to the mandated reporting requirement was the addition of clergy to the list of mandated reporters in the wake of the Catholic sex abuse scandal. That's the only substantial change. There was a substantial policy change a few years ago, but it's been around so long that most people just think it's always been like this. Prior to this policy change, domestic violence was not counted as a form of child maltreatment. It was excluded as not being in a referenced form of child abuse. That's no longer the case. It's not mentioned specifically in the statute, but they no longer screen it out by rule. And in fact, exposure to domestic violence is considered a form of potentially damaging child maltreatment.
I also heard there in terms of domestic violence, there's a new language or verbiage, something to do with coercive control or something or other. Does that ring a bell?
Yeah, I think in the current legislative session, I didn't see it went through last time, but in the current legislative session, there is language in Massachusetts in an effort to place into the statute itself patterns of coercive control. And that's partly to try and get at situations where the domestic violence or other things that are happening, like trafficking of partners, is more clearly recognized in the statute. The statute is still the same in the sense that the statute is intended to protect vulnerable children from their caregivers, either familial civilian caretakers, if you will, or professional caretakers. And so if, for example, you learned in a therapy session from a 13-year-old that he or she is being groomed by a family friend who's not in a caretaker role, or a neighbor who's not in a caretaker role, but they're being groomed for sexual exploitation, for example, that would not fall into a DCF bucket, a child protection bucket, unless you had reason to believe that the parents knew or should have known about the grooming that was going on and failed to take steps to protect their child. Then that would be a neglect, because they're not directly involved in the sexual abuse of their child. That would be a neglect. But if it's a third party, not a caretaker, and not one of the designated professionals who are themselves mandated reporters, those go to law enforcement.
Does that also apply to Washington State? I'm sorry, I didn't raise my hand. I jumped in.
I think the fair answer to that is I think so, but since I don't practice in Washington, and some of these are quite local themes and variations, it would probably be easy enough to find out in Washington whether or not, look at the statute, for example, and see if the language of coercive control is already there, or look at their definitions of who they think they are protecting. Right.
Thank you.
So there are some variations in Massachusetts. You had asked Natalia also about, differences that we should probably want to know about. So there's one difference that's notable in the confidentiality and privilege framework in Massachusetts. If I'm a licensed psychologist and somebody sits down and tells me, one of the reasons I'm coming to you is that I have been terribly troubled by something that I did 15 years ago. In fact, what I did was so terrible I can't live with myself. I killed somebody. In Massachusetts, you're not free to report that outside of the therapeutic relationship unless there's something like a continued imminent risk of severe injury or death of an identified person, right? In Massachusetts, social workers have the discretion to report a past crime to police.
And there's no limitation to that. We are concerned with immediate danger to self or others, not something you have done last year.
Ordinarily, that would be the case, but it's very clear in the psychologist's rule that unless it's triggering a current warning, right, you can't release that information. You don't disclose that information, or if you do, you only disclose what you need to disclose in order to affect the protection, right? So if I think somebody is a danger to a third party, and I think that part of that danger is complicated by some mixture of a psychotic disorder, but also a complex PTSD in the picture, I don't need to tell the people at the psychiatric emergency screening room about the details of a history of sexual abuse and so forth. I just tell just enough to achieve the goal, which is immediate protection. So if I'm a psychologist and one of those doors isn't open, I can't disclose this to law enforcement, even if I think it would be a good idea. If I'm a social worker, I don't have to, but I can. And that's just the way the legislature was thinking at that time, if they've never gone back to revise it.
Robert, I just want to interrupt for a moment. I don't want to get derailed on state-specific information. If we can, we got a long way to go in this presentation and very few minutes left. So if we can continue with the presentation, if you have more general questions, we certainly can answer those, but let's try to stay away from state-specific.
Okay, and we go till 3:30, yes?
3:30, yes.
3:30. Okay, I'll pick up the pace here a little bit, but I
Thank
wanted
you.
to get this foundational stuff. A lot of times, the first step in thinking about what you are trying to puzzle through is to figure out which bucket it is in. These overlap, of course, but they are different. So if somebody calls me up and they said, "Here's my situation, and am I a mandated reporter?" My first question is, well, where are you? Because if it's an expiration date, if it's in Michigan and it happened 8 years ago, then that's a legal question. That's a question of what the licensing authorities and the legislature in Michigan want you to do. If it's a matter of whether or not this is within my scope of practice, that is kind of a combination of law and regulation and risk management. You're entitled to develop skills outside of your original scope of practice or your original competencies of practice, but you have to be able to show that you are getting the right kinds of training and supervision to be able to do it. Risk management is the literally, how do I mediate or moderate risk either to my patient or client, a third party, or to myself or my organization. And risk management is one of those things where you really want to be thinking about how serious the consequences are of getting it wrong, like whether or not to hospitalize if somebody appears they may be suicidal to some degree, and what you would need to show people. So I've sometimes heard people give the advice of, well, just write down as little as possible. That's stupid. If I can just sum up, that is stupid. What is prudent is to write a note about the decision making, about what you did, what you decided, why you decided it, the basic information you were relying upon, whether or not you consulted with somebody else, which is always a good thing if the answer is yes, because consultation is evidence of your professional prudence. But it can't be, have you got 3 seconds while I'm walking you to my car? I mean, it has to be a real consultation that would be recognizable as such. And why you didn't do what you didn't do. So I've seen suicide risk assessments where they wrote down why they let the person go, but they didn't write down why they chose not to hospitalize, or they do it the other way around. What you want to do is be able to give somebody who's an objective, reasonable decision maker enough to see whether or not you were somewhere in the bell curve of the standard of practice and whether or not you were prudent. And so knowing which bucket you're in is an important piece, although all of these buckets, of course, are involved in clinical care and decision making. So what we're looking for are, what are the frameworks? We like to focus on the rules, and the rules are important to know, but as important to know is what are the frameworks? Where are legislatures, where are we, where are third parties, where are our organizations striking balances? And there were, the ones that are easy, and then there's the rest of them that are not, and so required some thought. So we want to distinguish between preferences, interests, and rights. We also want to know and consider when somebody claims they have a right, a legal right in particular, which can be distinguishable from a moral right, but a legal right. Why do you think you have that right? Where do they get that? So, for example, in the United States, we have entitlements to healthcare because our legislatures and the Congress create these frameworks for care. And once they've created these frameworks, they have to be operated competently. But there's only one population in the United States that actually has a legal right to health care that is minimally competent. We have interest in competent health care, but we don't have rights. We may have entitlements, but we don't have rights. The only protected population are incarcerated persons because they have no freedom of choice over the care that they get or don't get or the quality that they have access to. So the words rights have to be used very carefully and very thoughtfully because they are absolute. Interests are negotiable. And so those we can have a little bit more flexibility. When somebody, the other thing that I would urge you is when somebody says that's unethical, that's an unethical thing that you're about to do in your clinical practice, ask them to point where in the ethics code you actually find this prohibition or even this caution. Because a lot of times people have very strong ideas about what is unethical. They may be reasonable, but they're more personal usually than you would see reflected in codification in an ethics code or a law. So when considering a situation, you want to think about what are the facts here? And you also have to be mindful about how certain you are about the facts. And so the world wants you to behave sort of reasonably prudently, but also know what is relevant and what may be irrelevant. So quite frankly, if somebody tells me in a clinical interview that they were born in Fort Wayne, Indiana, what do I know? I know only that that person told me they were born in Fort Wayne, Indiana. When I'm talking to somebody in clinical interview and they say, sometimes I cry without reasons. I don't know why I'm crying. And sometimes I have nightmares about terrible things that have happened. I know that they've told me that. I'm allowed as a professional to accept as an assumption that people are largely going to tell me the truth because they want good care and they want to be relieved of their suffering or their functioning upgraded, supported in some kind of healthy way. But I don't really know they have nightmares, right? And so when we begin thinking about other sorts of things, especially when people may have very different interests, like when parents get a divorce and it's hotly contested, and one parent, without the knowledge of the other parent, goes to get psychological care for one of the children who's involved in the divorce, and they tell you what's going on. You know what you've been told, but you don't know for a fact unless you witnessed it, or you can get some reasonable corroborating information. We deal largely in narrative truth, and most of the time that is good enough. But sometimes the stakes are so high, or the reality context, including legal context, are so significant that it actually matters what the philosophers would call a veridical truth. That is something that is really true as to how I understand it, which is a narrative truth. So you want to think about what's the fact pattern? What are we trying to decide here? What's the issue? And does it live mostly in a legal, clinical, or risk management bucket? So using the sources of our professional ethics, ethical reasoning and legal reasoning will be a deliberative process. We're thinking about what are the values: autonomy, safety, patient well-being, all these big ticket values that are reflected in these issues that we operationalize, usually as interests, sometimes as rights, and then a process of reasoning that is open to the scrutiny of others, that we could explain ourselves quite literally in a way that would be viewed as reasonable and prudent. And there will be times when reasonable people can reasonably disagree, and those we call a dilemma. And those are ones where especially we don't want to Lone Ranger. We want to go to somebody whose wisdom and experience we trust, and present them with the dilemma to get their view on the best way to proceed. I will tell you that there are people whose judgment and experience I greatly value, and it's precisely for that reason that I do not maintain a social relationship with them. I don't want to be playing pickleball with my consultants. Right? I want to have an arm's length relationship, because a consultant needs to be somebody who can honestly tell you candidly when they think you got it wrong. And that's very hard to do when we have friendships that are also part of a professional relationship. They're very difficult to untangle. So just a little roadworthy advice. And then we'd look at sources of legal authority, statutes, regulations, cases. We'd reason about them. We would have our thinking guided by the relevant law, statutes, regulations, cases, which also means we have to have some familiarity with them. I, for a time, was chair of the ethics committee at the American Psychological Association, and I did a non-scientific review of the people in the first year when I was chair had complaints against them. 0% of the people who had an ethics complaint against them acknowledged or reported or endorsed that they had read the AP Ethics Code within 2 years of when the ethics complaint was filed. Many of them literally did not know, or they knew, but they knew if they read it or talked to somebody about it, people would say that's a really bad idea, and they were bound and determined to do it anyway. So you don't get to claim ignorance in this, but it also means we have to know what the statutes are. These are some of the balances we strike in behavioral health care: privacy, safety, equity, autonomy, quality and effectiveness of our care. And we're constantly trying to balance this out. And it's rarely a zero-sum game. These are the kinds of values. I'm going to skip through these a little quickly because you'll be getting the PowerPoints as I understand it. So you can take a look at these and think about decisions that you have made in a clinical context where one or more of these are implicated in the decision that you make. And some of these are really quite big ticket items. So some of them are to support well-being, like the ones back here. We want to enhance. These are the preventing harms, reasons why we behave in particular ways or decline to behave in particular ways in order to protect our patients or clients, third parties, misuse of our influence, discrimination, protect the integrity of therapeutic relations and professionals in the profession. Where these rights and interests exist, these may create obligations. And in order to have a duty, you have the structure of a licensure complaint or a malpractice suit is, did you have a duty? Were you derelict in that duty in a manner that directly resulted in harm or damage? Sort of the 4 Ds: duty, dereliction of the duty, directly resulting in harm or damage. So when there are dilemmas, we want to really be mindful about identifying, do we have a consensus on what the facts are? Because if not, that's a good place to begin. And if the key facts are disputed, we have to ask ourselves, are these meaningful disputations? Does it matter? Because if it doesn't matter, then the fact probably doesn't matter. But
you muted yourself again.
Robert, we can't hear you.
now you can, I think.
There we go.
Yeah, this is magic to me. I'm not even touching my keyboard. All right, so we want to think about the core values. We want to articulate the nature of the conflict, and we'll get to examples of that in a moment. And then I like to go one extra step and consider the relative vulnerabilities of the parties who are involved, because sometimes people are not on equal playing fields. There are significant power imbalances that we have to take into account. Let me see if I can do this without muting myself again. All right. So in the ethics codes and guidelines, this reflects a consensus of professional practice. You are not required to follow professional guidelines if they are called guidelines. But I will tell you that if something is recommended in a guideline and you choose not to behave in a manner consistent with the guideline or make a decision in a manner consistent with the guideline, you're going to want to be able to articulate why that is, because guidelines are essentially the consensus around decision-making and practice. For psychologists, the ethics code is being revised, and there are going to be some substantial differences between the existing code and the emerging code. So take a look at it as soon as it comes out, or even if you want to weigh in on it while it's still in the public discussion phase. There are some red lights, many of which are also now codified in law. A few things that are now regarded as red lights that have not always been regarded as red lights: sex with patients, students, or supervisees, using of obsolete tests and outdated test reports, practicing outside of your scope of competence without adequate training and supervision. There are lots of yellow lights. These are you may be getting into a swamp, be careful. Dual relationships. There are definitions for multiple or dual relationship in the codes. Sex with former therapy clients, it's not a no-fly zone forever anymore, but it does put the onus on the professional to show after a period of no-fly why this is not exploitative or harmful. Barter used to be permitted, then it was not permitted, now it's
You're muted again.
And I'm off again. I'll just start monitoring that because I don't know why it's turning itself on. And some green lights, which are very handy, that explicitly allow us to provide services in emergency circumstances that might ordinarily be under might ordinarily be outside of our ordinary scope of competence, but we're the best that we've got under the circumstances. One change that was made in the most recent psychologist code is it is no longer patient abandonment if you terminate a patient who has posed a material threat to you or your family members or other people. You are no longer obligated to continue to be threatened while you provide services. And I've certainly had my fair share of people who made terrible statements and threatening things about me, and then they say, "But I know you can't get rid of me because I'll sue you for abandonment." And I'm like, no, not anymore. All right. So establishing the 4-bucket framework, the critical elements of informed consent. Who are your clients? Who are you working for? Who is the person that is the recipient of your service? And distinguishing between legal and ethical clients. So if you have a minor child, for example, the person who can give the informed consent in most situations is the parental legal guardian. They are the ones that negotiate with you about the course of treatment. They can terminate the treatment on behalf of the minor child. They are your legal clients in your ordinary assessment or treatment. But of course, we want to do our jobs well. We want to remember that centered in our professional ethical obligations is competence of the services that we will give to that minor child. And to appreciate that it's important for us to know when a professional relationship begins and when it ends, when it's over, so that we know we are no longer in that special relationship with these special duties. I used to be a consultant for one of the couples and family services at a hospital here in Massachusetts, and they would often have these contentious couples, and one of them would decide to not come to the couples therapy for a while, and then without terminating the couples therapy, the family therapist or the couples therapist would agree to see the remaining spouse or partner as an individual client without terminating the case. And then the client who left comes back and says, I took a little therapy vacation, but now I want to read the record to catch up. That's an avoidable problem by knowing when a couples therapy ends and an individual therapy begins, or having a practice, as many of my colleagues do, that if they start as a couple, then if they need individual, one or both of them, they will refer on. They won't continue to see just one out of a couple that started together. The role that you have in providing the services, knowing what you are doing and being clear what you'll be doing with them, disclosure of a supervisor or a trainee status. We'll talk a little bit more in a minute about the distinction between a supervisor and a consultant. But if you are a supervisor, remember, you are claiming that you have full legal, ethical, and clinical responsibilities over the case or cases that you are supervising. Sometimes we are really consultants, even when we have a supervisor role in the title. The rest of the world thinks that we're claiming it's our case and we've just lended to another professional or to a trainee, but it would really be ours. So the goals of care, risks and benefits of the care options, risks and benefits of if there's no care, what's the natural course of the illness without treatment. Transparency, you can do experimental treatments, you can do treatments that are not evidence-based, but you have to tell the person as part of the informed consent that this is not an evidence-based treatment that you're providing. However, and you can go on and say, I've done this work for years, and many of the patients say I benefit from it. We're getting very close to the point where, especially the treatments for anxiety and depression, if there's not a good evidence base, would probably be required to disclose the treatments that we may still use that are not particularly evidence-based. It's really a gray area there at this point. And the disclosure of any limits on confidentiality and privilege. And there's sort of an art of doing this, especially with younger people, because the parents will often say, tell me, I want to know everything. And the kid will say, I don't want you to say anything to them. And so you have to kind of negotiate a mid-ground of reserving some discretion to protect the privacy of what the young person is telling you, but also making it clear that if there's something that a parent would have a legitimate interest in regarding a significant issue of the well-being of their child, the kid knows that you're just not going to sit there silently while they continue to do IV drugs or engage in promiscuous, unprotected sex and the like. Expectations that you have of them. If you're in a cognitive behavioral intervention, for example, being clear with them about what, if any, sort of homework or activities or in vivo kinds of things you're going to want them to be doing with you. Costs and fees clarified, and clarifying responsibilities for costs and fees before you initiate the professional relationship, so you don't get stuck in odd places where somebody's receiving the service and the person who nominally would be paying for the service is not at all interested in doing so. You want to know that sooner rather than later. Discussion of any crisis plans or emergency plans. So one of the things we encourage the couples therapist to do, especially if there had been episodes of partner violence, was, as part of the initial phase of treatment, constructing a mutually acceptable crisis plan, especially when there were children in the home, the family, and getting appropriate clarification of when the services might be altered or terminated and the process by which that would occur. Informed consent is a process. It's not a moment. You don't have full informed consent for a prolonged treatment, for example, just because they signed a piece of paper at the first or second appointment. There's a duty to review the informed consent whenever there is a meaningful process or a material circumstance that warrants it being revisited and perhaps revamped. So areas where the law is most often relevant to practice: protection of vulnerable parties. This will also vary by state. So in Massachusetts, we have a duty to protect elders over 60. I'm over 60 now. I'm a little miffed that the legislature thinks I need special protections for myself, but they may be right. Under 18, I can sort of get that. I haven't had to worry about being under 18 for many decades now. But what about disabled persons? What about persons with disabilities? Well, I often hear behavioral health professionals in their informed consent say that they would have to disclose maltreatment of a disabled person. It turns out our legislature didn't see it quite that way. They did not want to make disabled persons legally cognizable handicaps. They did not want to create a presumption that they were incapable of making their own consequential decisions in their own best interests. They didn't want to create a world in which we thought that persons who were blind, for example, were more like children under the age of 18 or potentially dementing elders. So there is a mechanism for reporting maltreatment of a disabled person between the ages of 18 and 59, but it requires the consent of the disabled person unless they're under guardianship, and somebody else has to make that decision for them, right? So we need to know that. Protection of third parties. There are other exceptions to confidentiality, many of which will get covered in things like how their insurance might be reviewed or utilization reviewers, all these other sorts of things. Who gets to do the informed consent? Your relicensure, continued professional development and professional education, especially if you are expanding outside of your current scope of competent practice. And here's where we really want to be thinking carefully about the rules of the road: co-parenting and minor patients. If you're going to work with folks in divorced child custody as an evaluator, as a therapist, you're going to want to know what the terms of the court's orders are. Are these joint custody, in which case you need two parents to agree to a medical or a behavioral health intervention? They both carry keys to the launch code. If it's single custody, single legal custody, but joint physical custody, that means one parent is the decision maker, but they co-parent across two households. So knowing the difference between what is legal custody, what is sole custody, what is physical custody, and the rules around that would be really important. Responding to requests, you want to know the rules of confidentiality. Sometimes people get flustered about the difference between subpoenas and court orders. A way to think about it, first rule is never ignore either one of them. People sometimes show odd perturbations in their object relations when they get a subpoena or a court order. They put under a pile on their desk, and then they're like the toddlers when the ball went under the chair. When they can't see it anymore, it isn't there. That's not how you want to do this. But think of subpoenas as kind of a date. You're being asked for a date by an attorney. Subpoenas live in stacks in courthouses at the clerk's desk, and it only requires the signature of a subpoena. Don't ignore a subpoena. Get a consultation if you're not familiar with practice in this area about how you can have negotiations with the attorney about when you'll show up, what you'll say when you show up, what you'll bring. You can make arrangements to have it quaffed, meaning have a court dismiss the subpoena so you don't have to reply to it at all. If you're a line clinician, let your supervisors know and an administrator know if you get a subpoena. Court orders, you basically have to do what you're told. But you also want to make sure that you're prudent when you do this. So when I receive a court order to bring records and be prepared to testify at a court hearing, I try and clarify in advance what it is that the court wants me to testify about. And I also try to clarify in advance, has the patient asserted their testimonial privilege? And if so, has the court already ruled to waive it? Because in about half the times the court hasn't made the decision yet, they didn't even know it was live on the table until I showed up and said, here are the records, but before I can give them to you, I have to know that you've waived the testimonial privilege. We've reviewed when the professional relationship is over, standard of care. If you're going to be working with especially high risk or challenging populations, know the standard of care within that particular practice competency, what most other practitioners in your field with this challenge would do if faced with it. Remember that if you declare yourself a specialist, I'm a specialist in, you are ascribing to a higher level of care than the average practitioner. So one of the things I have to tell my very happy graduating doctoral students when they finally get their PsyDs and they're going to get licensed, and they proudly show me their new business cards that will say things on the business card like specializing in the treatment of eating disorders. And I ask them seriously, you haven't had your license 6 months yet. Are you really claiming that you have the expertise that you would find at the Boston Children's Hospital in their eating disorder service? Because if you aren't, you may not want to be telling the world you're that good quite yet. So words like specialty and so forth are really important to understand that that also comes with heightened responsibilities and duties for competencies in that area. As I mentioned before, consultation, you can receive consultation and you can disregard it if you choose to. If you are in supervision and your supervisor tells you to behave in a particular way or act on a particular decision, it's not your choice anymore. It's their case. So a lot of times people will say they're in peer supervision, and I will ask you, you're really claiming mutual responsibility ethically, legally, and clinically for all of each other's cases? And they look horrified and they say, of course not. And I said, you're not in peer supervision, you're in peer consultation, and that's fine, but don't accidentally be claiming things that you really don't think you're embracing. Keeping records during and after care episodes, know the rules of the road in your state or in your licensure. In Massachusetts, a child's records, for example, have to be kept till age 18 plus 3 years. In other states, it's longer. In other states, it's shorter. It's not clear in Massachusetts if you have done something for litigation, like an evaluation that you did for court purposes. That's not considered a treatment record, and it's not clear how long you have to keep forensically generated records. And the presumption is probably forever unless you file a copy of the report with the court, and it's in the clerk's file, so it will be maintained in perpetuity by the court itself as part of the case file. Professional practice across state lines. This is really interesting and challenging process. And now Massachusetts, has Washington joined SIPAC? Anybody from Washington on this call? SIPAC is the agreement amongst states that they will recognize each other's licensures for purposes of cross-border telehealth. It's in process there as well. Okay, it's in process here. Massachusetts psychology community has been very reluctant to push SIPAC, but I think they're beyond that now. Just know that depending upon the jurisdiction that you are in, there will be different rules about where your practice is taking place, and they may feel more or less grumpy about it. So there are some states that do not offer temporary practice. And so if I'm standing in Massachusetts and I'm having a telesession with somebody who's gone on vacation for 2 weeks, and I'm having my regular session with them, but they're in a state that doesn't acknowledge SIPAC or something very similar to it, I can be criminally charged for practicing in that state without a license. Doesn't happen very often because people don't often find out about it, but it can happen. Just appreciate that if you're crossing state lines, you want to make sure you have the right kinds of permissions, credentialing, or avenues like SIPAC. All right. Comments, questions? This is sort of a general framework to help you think through. My goal here is to help you get to a point where you might be able to recognize this is a situation where I should probably tap the brakes for a minute and ask. Because if you have any doubt in your mind, it's worth asking. And if you do this work for a while and you never have any doubt in your mind, I'm worried because you should. Because there are plenty of gray areas and areas of tension in what we navigate every day as clinical practitioners. So comments, questions?
I have a question.
Sure.
I know we're not doing state specific. I don't know what the laws are in other states, but I'm in Massachusetts. So I work primarily with kids. And I know in Massachusetts, we have to have consent from both parents if there's shared legal custody.
Yeah.
One of the things that I keep running into is when there is no legal custody agreement in the court, there, just common relationship that has ended. In Massachusetts, the custody is supposed to default to the mom. Like legally, that's my understanding. But then I don't know if I'm supposed to be trying to sometimes I can't get a hold of, or the father is out of state and not participating in life of the child. So the assumption is that if they're both not married or not together, that I have to get consent from both. But I'm wondering if you have any information on how to navigate that part when there's no custody agreement and technically custody defaults to the mom.
Well, you might want to suggest to this person that they go get a statement from the court regarding the paternity, especially if the father is no longer anywhere to be found. But I would also suggest that you be able to show a good faith effort, that you try to identify and locate this, because I know you're going to find this shocking. Sometimes people who have had ugly separations don't want to see that person before. They certainly don't want to talk about them. They certainly don't want the therapist sort of weighing in on all of this.
Now you can hear me.
Yeah. So what I would recommend is make sure that's the case. If they have ever been in a divorce proceeding, there is what's called a divorce nisi. And sometimes people will say they're divorced and they're the sole custodian. Sometimes that's even true. Often it's not. So ask for a copy of the divorce nisi and it will specify. Remember that unless a court specifically bars otherwise, in Massachusetts, even if you don't have legal custody of your child, you have residual rights to inspect medical and educational records, unless the court has said, and those residual rights are also terminated for you. So the ones that are most challenging, I think, are when somebody comes without telling you that they're involved in litigation or in an unhappy separation. So I think it's wise as a standard intake question. Are you currently involved in any litigation, or is it foreseeable that during the course of our work you will be involved? Because sometimes people are taking children mostly for assessment and therapy services on the basis of some maltreatment, only to discover later that whether or not that maltreatment ever occurred at all is precisely what's at issue. And understandably, if somebody takes a kid takes one of their children for assessment and workup of trauma, that's then usually what we sort of presume, because in most cases, when a parent does bring a child for care, their intentions are good and so forth. But I've certainly seen cases where trauma was alleged, maltreatment was alleged, that ended up being precisely what was at the heart of the litigation. And by the time the people who were treating the child's trauma got finished with a few sessions, they had really muddied the forensic waters on what a trained forensic interviewer of a younger child especially would be able to get. And it makes things very, very difficult.
Thank
I have a
you.
quick question from the chat. Could you talk quickly about the age of consent when a client has no ability to pay because they're a child or they're a minor?
Yeah, they have the ability to consent. That does not create an obligation of you on your part to provide free care. You would have an obligation to provide free care if it was an emergency circumstance. Like if the kid came in and said, I'm suicidal, I think I need to be in the hospital, and I'm fill in the blank, whatever the age is to consent. In Massachusetts, you can sign yourself into a DMH facility at age 16, right? So you would want to take the steps necessary to secure safety in the moment, in that emergency. And you would be permitted and even required to do so. You can't say, well, I'm sorry you're not suicidal, but if you don't, I'm sorry you're suicidal and think you need to be in a hospital, but you don't have a copay today, so go away. You wouldn't want to explain that to anybody. But you're under no obligation to continue to pursue the care. And then you might be in a situation where you'd have to decide whether or not the person who is financially responsible, the parent, for example, their failure to get that child to care either with you or to somebody else rises to the level of medical neglect.
Thank you.
Any others?
Thank you, Robert. Quick question. Is there another form? Because I do have a client waiting. No,
No more
just the
forms.
one.
The next one you'll get will be via email.
Awesome. Thank you so much.
Okay. I can stay here for another few minutes if anybody doesn't have a client waiting and would like to make a comment or ask a question.
I would like to ask a question, if that's okay.
Sure.
Hi, my name's Allison. I'm a clinic director in Haverhill. We have a 17-year-old client that sees a therapist here, and he eludes to like sociopathy. He keeps alluding that he might be mutilating animals, or he did something that if he tells the therapist will have to involve the police, but he hasn't given a clear disclosure or any type of factual information. Is there any legal obligation the therapist or myself has in this situation where there's eluding to but not disclosing?
Yeah, well, here's the pragmatics of that. If he hasn't disclosed and he's alluding to this, and you don't have a reasonably identifiable victim, this is a third-party protection, I take it, right? A reasonably identifiable victim, then there's 4 things you can do in Massachusetts. You can warn the victim, you can tell the police, you can try to voluntarily hospitalize, and you can try and involuntarily hospitalize. Pretty limited menu. If you don't know who the victim is, then you can't really warn the victim. If you call the police in Holyoke and say, this is what this kid is alluding to, they will ask you, has there been a crime committed? And if so, where was it? Because if there hasn't been a crime committed, and if so, where was it? They don't know what they're investigating, or even if they have jurisdiction over it. If the crime was committed in southern New Hampshire, the Haverhill police would have no jurisdiction there, right? The third is voluntary hospitalize. I'm not hearing you say this guy is eager to go into an inpatient unit. And if you're really worried about him, I suppose you can try and do a section 12 looking for involuntary civil commitment, but without more, just on the basis of an eluded threat. I can't see a judge doing an involuntary civil commitment, and because you wouldn't be able to show the magnitude of the threat or the imminence of the threat, or the fact that that this was a result of a mental illness. Remember, you can have all kinds of dangerous thoughts, but if they're not a product of mental illness, if they're a product of your criminality, then that's not a psychiatric problem.
Right.
So-
Now, if he does make, oh, sorry.
Well, what I was going to say is if until he decides what it is he wants to do, to tell you or not, I would handle it as a clinical question, a clinical issue, which is, all right, you've told me this, I understand. What are you hoping I will do about it? Because if the kid is merely doing this to make you anxious and torture you, then it's important to get clear on that. And that would be a little evidence for I might be in the world of somewhere between a really provocative adolescent, but one I might someday come to love, or I really am watching a little junior sadist who is getting his jollies out of watching me get anxious. And so thank you for alluding to this. What do you want me to do? Do you want me to help you understand why you think this way? Do you want me to stop you from actually acting on this? Here we are. What do you want me to do?
Okay, that's great. And then also, if he does make a disclosure, let's say hypothetically he discloses that he did in fact mutilate or kill an animal, what are the obligations we would report that to the police, the local police, and the parent, of course. And would that also be a 51A for lack of supervision for a minor?
Well, do you have evidence that there was lack of supervision? Just that the fact that a kid did something obnoxious or terrible outside of the parent's vision doesn't make it a lack of supervision issue.
Okay.
Otherwise, we just put barbed wire around Wyoming and parachute parents in of adolescents.
But if he does mutilate or harm an animal, do we report that to the police?
Do you know when and where it occurred?
No, I'm asking if and when, I want to be prepared,
Okay.
if there is a disclosure.
Okay, if he does start going down that road, then I would try and get as much concrete information as I could.
Okay.
In the same way, if somebody says, a lot of times I think of killing myself, then one day they say, I think I'm killing myself today, and then you talk to them about intent, opportunity, plan, means, all that sort of stuff. And then since what is a mandated report for purposes of criminal investigation is somewhat different than purposes of child protection, I would get as many facts as I could, and then I would get a consultation about whether I make a report, and if so, to whom.
Thank you.
If you want, Allison, you can call me.
Yeah, we might. I might.
I'm serious about that.
Yeah.
I'm not going to charge you for the time. So, but here's the deal. When I do consultations like this for folks, then I need to know what happened, because I can only learn if there's a feedback loop.
Right.
So
Okay.
if people call me for consultations, I won't charge them money for it, but I do want to learn from the experience with them and find out what happened in the real world, whether it made a difference positively, negatively, or not at all.
Thank you so much.
Any other questions, comments? All right, and so I will conclude by moving to my professional icon, the fabulous gonzo journalist, Dr. Hunter S. Thompson, who advised us all, when the going gets weird, the weird turn pro. Welcome to behavioral healthcare in the 21st century.
Thank you so much for your time today, Robert. We appreciate it.
Thank you for the opportunity. Take care.
Thank you so much.
Thank you, sir.
Thank you so much. Very well done.
Thanks, Jack.